Good morning to everybody. Thank you so much for being here in Rome and for being online. We open today this workshop devoted to the advisory opinions of the International Tribunal for the Law of the Sea. And I am very happy to have here with me many renowned experts of the law of the sea gathered here today to discuss and talk about the advisory opinion as a tool for improving even international law. And now what is very important recently, we have had a landmark opinion from the ITLOS in 2024. So this is why we really ask, we really wonder what are the possibilities and the potential of advisory opinions in changing or influencing in international law and also the behavior of states. So this is really important because we are dealing with the fight against climate change, and there are many aspects of the recent practice of states that are in the direction of fighting against climate change or trying to find solution to this issue. So I would like also to underline that this workshop has been organized in the framework of the future national Center for Biodiversity, where we are leading a task of for maritime spatial planning, and in particular policy coherence and cross compliance, and that it is also organized with the ACIDMER, and we have today also our president, and so I want to really immediately give the floor to the first speaker. We also have the honor to host two judges from the ITLOS, and one is a renowned expert in international law and will address the issue on general aspects of advisory opinions, and the Professor Caracciolo is also the person who contributed to the landmark decision on climate change. So I thank you warmly to our guests, and I give immediately the floor to Professor Frida Armas. Thank you so much.
Okay, good morning, everyone. Sorry for this delay. Well, it is an honor for me to participate in this workshop, and I thank particularly the Institute of International Legal Studies of the National Research Council, particularly its director, Professor Andreoni, for inviting me to share some thoughts today on the advisory proceedings of the International Tribunal for the Law of the Sea. And it's really a privilege for me to be in this session together with Judge Ida Caracciolo and Professor Giuseppe Cataldi, Caligiuri, and Borgia. Thank you, all of you, for being here. And I want also to thank all of you to be present online or online with us today. So the topic that gathered us is the advisory proceedings of the International Tribunal for the Law of the Sea, particularly with focus on the 2024 advisory opinion on climate change and international law. I join those who consider this is a landmark advisory opinion, really, and it is also an historic precedent in these times when the issue of climate change and it's okay?
Okay, yes.
And climate change and its consequence is being considered by important legal bodies like the International Law Commission, with its Something?
No, it's okay. You can continue.
The International Law Commission with its report on the climate change, but also two international tribunals, the International Court of Justice and the Inter-American Court of Human Rights with its report on climate change. Do you want me to stop?
Just 1 minute because we want to see it.
Okay. No, yes, no problem. I just didn't know if I had to wait for me.
No, mi too.
Cosa scritto meno bene?
Visualizzazione e griglia.
No.
Altre azioni.
Qua.
Sì.
Visualizzazione del relatore.
Ok.
No, it was,
And you can go here. You can go here with the
Cioè la
presentation.
modalità presentazione in realtà.
no, but
You can.
yes, but it's not better to put everything. But
It's
no,
good. Do you
You
want?
can go.
no, it's for me. It's whatever you want.
Okay. I can go further with the.
But can you not put it on the whole
because
screen?
otherwise people at home don't see.
Okay. If it's okay for you, we'll see. Okay. Well, and so I was saying that it's an important present because of the other legal bodies, the International Law Commission and the two tribunals which have the advisory opinions pending, ICJ and International Inter-American Court of Human Rights. And I can, no, it's okay, go back. I can do it. I can freely praise the tribunal for this advisory opinion because I was not part of it when it was adopted. So indeed, the request of the advisory opinion was submitted in December 2022, and the written and oral proceedings ended before October 2023, which was the date that I was sworn in as a member of the tribunal. So that advisory opinion was adopted by the sitting judges at the time of its submission, and none of the 6 new judges participated on it. So thus, I'm going to refer to the advisory jurisdiction of the tribunal in general, and in particularly how it deals with the jurisdiction in this last advisory opinion. But then Caracciola is going to address the substantive issues of the opinion. Well, as we know, for all international tribunals, the advisory jurisdiction is a key tool in order to determine the principles and rules in force, and also to interpret and apply them in order to provide an answer with a legal basis to the questions submitted to the tribunals. So despite not having no binding force, all advisory opinions carry legal great weight and moral authorities. And in their own way, advisory opinions also contribute to the clarification and development of international law, and this is really one clear example of this. And the requirements for the use of the advisory jurisdiction are not the same in all the tribunals. No? For example, in the International Court of Justice, the General Assembly and the Security Council are entitled to request an advisory opinion, while other United Nations organs and specialized agencies must be authorized by the General Assembly. And at other tribunals, like the Inter-American Court of Human Rights, this are the states, the ones entitled to request an advisory opinion. Well, in the case of the International Tribunal for the Law of the Sea, we have a particular situation because the advisory jurisdiction for the full tribunal, for the plenary of the tribunal, is not explicitly or literally provided in the convention. The advisory jurisdiction, I cannot change the range. The advisory jurisdiction in the United Nations Convention on the Law of the Sea is mentioned only in relation with the Seabed Disputes Chamber. But as we will analyze in this presentation, the tribunal, I'm putting just some slides for guiding the presentation, but I will speak in general. As we will analyze in these presentations, the tribunal, in its rules of procedure, through Article 138, established an interpretation of the convention and the statute that make it full possible that make it possible for the full tribunal to issue advisory opinions. So, as we said just now, the advisory jurisdiction of the IDLOS is, as provided in the convention, is only in relation with the seabed dispute chamber. And the seabed disputes chamber has a special place at the tribunal. It is established by the convention in part 11, that is the part of the area, the seabed and subsoil beyond national jurisdiction, even if it is a settlement of disputes organ, body, a chamber. And it is not established in part 15, that is the one related to settlement of disputes. The seabed dispute chamber has defined itself as a separate judicial body within the tribunal entrusted through its advisory and contentious jurisdiction with the exclusive function of interpreting part 11 of the convention and the relevant annexes and regulations that are the legal basis for the organization and management of the activities in the area according to the common heritage of mankind principle. So the advisory jurisdiction of this chamber, of this special chamber, is connected with the activities of the authority and the council, the two main principal organs of the authority. So the chamber, being an independent and impartial body, is part of the system in which the organs of the authority operate, and its functions are relevant for the good governance of the area. So the chamber, that is, as it was defined as a tribunal inside of the tribunal, is composed by 11 members. It has compulsory jurisdiction, a part of this advisory jurisdiction, exclusively with respect to activities in the area. And in this compulsory jurisdiction, it is open to state parties, to the authority, to the enterprise, and also to natural and juridical persons. That really for 1982, when the convention was adopted, was very, very important development. And the seabed dispute chamber really faces the challenge to exercise its responsibility to ensure that the regime of the deep sea mining, as conceived in the convention and the 1994 agreement, is properly interpreted and applied. So, who can request an advisory opinion to the seabed dispute chamber? The Assembly and the Council of the Authority, of the International Seabed Authority, are the ones, according to the convention, that may request the chamber to give an advisory opinion. And the convention contemplates two different proceedings or two different situations. The first one, Article 159, paragraph 10, refers to the possibility to use the advisory jurisdiction of the chamber to assist the Assembly in the adoption of a decision. And it is specifically provided that when there is a proposal before the Assembly on any matter, any state, upon a written statement addressed to the President, but has to have at least 1/4 of the members of the Assembly who sponsor it, shall request an advisory opinion on the conformity with the convention of the proposal submitted to it. This procedure has not been used until now. It's in the convention, and I think it's very useful, but it has not been used until now. The other situation is foreseen in the convention in Article 191, according to which both the Assembly and the Council of the Authority may request the Chamber to give an advisory opinion on legal questions arising within the scope of their activities. So in this situation, the Article 191, there are three conditions that are necessary. The first, that the request come from the Assembly or the Council. The organ has to be one of these two. The second one is that it relates to a legal question. The request shall contain a precise statement of the question. And the third one is that the legal questions are within the scope of the activities of the organ, the Assembly or the Council, that made the request. Such opinions shall be given as a matter of urgency. It's specifically provided. And all the procedure for the request of an advisory opinion of the Seabed Dispute Chamber is detailed in rules, of the rules of procedure, Article 130 to 138, and detailed in the guide for proceedings before the tribunal, which intends to provide a practical information as to the manner in which cases are instituted and conducted before the tribunal. So these are the situations and what we have until now. We have the case 17 of the tribunals, that it was, in fact, the case of the civil dispute chambers, but all the cases, even if they are decided by a chamber, are considered cases of the tribunal. So case 17 was the one, because up to now, the civil dispute chamber has received only one request of an advisory opinion, and it was accorded to the last one, Article 191. The application was responsibilities and obligations of states sponsoring persons and entities with respect to activities in the area. And the request was from the council. So as I told just now, that there has to be three conditions. The organ, so the request was made for the council, so according to Article 191. There has to be legal questions, and the questions were very legal, very legal, because it was about responsibilities and obligations of state parties to the convention in relation with the sponsorship of states to activities in the area and the extent of liability. So, and the third is that the legal questions were within the scope of activities of the council, what they were. So the chamber found that the conditions were met. So the civil dispute chamber was issued the advisory opinion less than a year after requested, the 1st of February of 2011. It was an unanimous and significant advisory opinion, unanimous without any separate opinion, not only unanimous, but without separate opinions, and which has helped and is called to continue helping the authority in the task of managing the resources as common heritage of mankind. So we have just dealt with the advisory jurisdiction of the civil disputes chamber. But in the almost 30 years of the tribunal's activities, there were three advisory opinions, and two of the three have been given by the full tribunal, and only case 17 by the civil dispute chamber. But as we have anticipated, nor the convention nor the statute of the tribunal has an explicit or literal consideration of the possibility of requesting an advisory opinion to the whole tribunal. However, this omission was overcome by the tribunal when its regulations were issued, and because in Article 138, this possibility was explicitly included. We can see in the slide, the tribunal may give an advisory opinion on a legal question if an international agreement related to the purposes of the convention specifically provides for the submission to the tribunal of the request of such an opinion. So after approximately 16 years passed since the adoption of Article 138 in the regulations, before it was applied for the first time. And the occasion was this, case 21, that request of an advisory opinion submitted by the Sub-Regional Fisheries Commission. We call it a Fisheries Advisory Opinion. This request was submitted by the permanent secretary of the Sub-Regional Fisheries Commission on March 27 of March 2013, and the tribunal delivered its advisory opinion the 2nd of April 2015. The first issue considered by the tribunal was, as it was expected, because there was no application of Article 138 and no other full advisory opinion of the full tribunal. So the first issue was whether it has jurisdiction to give the advisory opinion requested by this subcommission. The tribunal recognized that while some participants have argued in favor of the jurisdiction to entertain the request, other participants have contended that the tribunal was not competent. So when the tribunal proceed to examine its jurisdiction, it highlighted 2 articles of the statute, 16 and 21, and one of the rules of procedure that it considered crucial for the analysis. Article 16 is related to the power of the tribunal to lay down its rules of procedure. So when it is going then to analyze its rules of procedure, says what they are according to what is on the statute, the power of the tribunal to do so. Then Article 21 of the statute is relating to the jurisdiction of the tribunal and which issues it comprise. And then Article 138 that we referred to. So the tribunal expressed the following arguments when arguing about its jurisdiction. First, that neither the convention nor the statute of the tribunal made an explicit reference to the advisory jurisdiction of the tribunal. And when I mean of the tribunal, I mean the full tribunal, the plenary, not the civil dispute chamber. But neither they explicitly denied it. So there is no explicit reference, but there is no explicit denial also. Second, that the annexes of the convention, particularly Annex 6, the statute of the tribunal, form an integral part of the convention. So from that it follows that the statute of the tribunal enjoys the same status as the other parts of the convention, and accordingly Article 21 should not be considered as subordinate to Article 288 of the convention that is related to the disputes. And it is funny what is said, that Article 21 stands on its own footing, not subordinate to or being subject to Article 288. This is important because the tribunal finds in Article 21 of the statute the founding of its argumentation on the advisory jurisdiction. And we say there that we can read there that according to Article 21, jurisdiction comprises 3 elements. No? All disputes submitted to the tribunal in accordance with the convention, all applications submitted to the tribunal in accordance with the convention, but also all matters specifically provided for in any other agreement which confers jurisdiction to the tribunal. So the tribunal highlight that the use of the words disputes and applications in the first 2 paragraph of Article 21 refers to contentious cases submitted to the tribunal in accordance to the convention. And this is clear because of Article 23 of the statute and Article 293 of the convention, which are dealing with the settlement of disputes and refer to disputes and applications. But it is the third element. It is the third element which has attracted different interpretations. The word matters should not be interpreted as covering only disputes, because if it were the case, the word disputes will be simply used. Consequently, the tribunal finds that it must mean something more than disputes. And this something more includes, in the opinion of the tribunal, advisory opinions if specifically provided for in any other agreement which confers jurisdiction on the tribunal. So the tribunal clarifies that the expression of Article 21, all matters specifically provided for in any other agreement, does not by itself establish the advisory jurisdiction of the tribunal. In terms of Article 21 of the statute, it is the other agreement which confers such jurisdiction on the tribunal because it's contemplated on the Article 21. When the other agreement confers advisory jurisdiction on the tribunal is then rendered to exercise such jurisdiction. So, in a kind of conclusion, we can say that Article 21 and the other agreement are interconnected, and they constitute the substantive legal basis for the advisory jurisdiction of the tribunal. And Article 138 does not establish the advisory jurisdiction of the tribunal, because it was sometimes criticized that the rules of the procedure were the ones who established the advisory jurisdiction of the tribunal. The tribunal found that not. The advisory jurisdiction was based on Article 21 and the other agreement. But Article 138 furnishes the prerequisites that need to be satisfied before the tribunal can exercise advisory jurisdiction. And what are these prerequisites? There are three. First, that it has to be an international agreement related to the purposes of the convention that specifically provides for the submission to the tribunal of a request of an advisory opinion. Second, that the request must be transmitted to the tribunal by a body authorized by or in accordance with the agreement mentioned. And third, that such an opinion may be given on a legal basis. In the case 21, the first one, the tribunal analyzed all this, the one of fisheries, the tribunal analyzed each one of the prerequisites and found that they were satisfied. So let's analyze the case before us today with the advisory opinion on climate change with this precedent in mind. It was case 31. It was as a request for an advisory opinion submitted by the Commission on Small Island States on Climate Change and International Law. It was submitted by a letter dated 12th of December 2022 by the co-chairs of the Commission on this Small Island State and Climate Change and International Law. And it was transmitted to the tribunal as a request for an advisory opinion pursuant to a decision of the third meeting of the Commission that was held on 26 August 2022. The tribunal, when analyzing its jurisdiction in this case, reiterates what it has said in its previous advisory opinion, the one on fisheries, regarding that its jurisdiction of render an advisory opinion is based on Article 21 of its statute and the agreement. And the tribunal further notes, when dealing with its jurisdiction, that its finding in the case 21 of this fisheries advisory opinion regarding the legal basis of the advisory jurisdiction has been supported by most states parties to the convention. And also that most of the participants in the written and oral proceedings in the case of climate change had expressed the view that the tribunal has jurisdiction to render the advisory opinion requested by the Commission. It was really a change between the statements of the states in the previous advisory opinion and in this one after what the tribunal explained its jurisdiction. Apart from that, the tribunal picked up as an argument in favor of its jurisdiction that the agreement and the last agreement under the Convention on the Conservation and Sustainable Use of Marine Biological Diversity on areas beyond national jurisdiction, the BB&J agreement, was the other, which specifically provides that the Conference of State Parties may request the tribunal to give an advisory opinion. And this agreement was adopted by consensus, and there were a lot of discussions on the capacity of the tribunal to give an advisory opinion. So this for the tribunal was also a signal of a way of consensus about its jurisdiction to give the advisory opinion. So as it was said, that Article 138 established the prerequisite to be satisfied in order of the tribunal to exercise jurisdiction. In this case, climate change, the tribunal did so. And the first, relating to the international agreement, the tribunal recognizes that the COSIS agreement, the agreement that instituted the Commission, is an international agreement which entered into force the 31st of October 2021, and to which 6 states at the time of the advisory opinion was requested. Now I think that they are 8, were parties, and that the basis of this COSIS agreement is the need to address adverse effects that GHG emissions have on the marine environment. So considering that one of the main objectives of the convention is the protection and preservation of the marine environment, to which part 12 of the convention is dedicated, for the tribunal it is clear that the COSIS agreement is an international agreement related to the purposes of the convention. So the first prerequisite is fulfilled. The second, regarding the body authorized according to the agreement, Article 1, Paragraph 1 of the COSIS agreement establishes the Commission on Small Island States on Climate Change and International Law as an intergovernmental organization with international legal personality. So also Article 2, Paragraph 2 of this COSIS agreement specifically states that the Commission shall be authorized to request advisory opinion from the Tribunal on any legal question within the scope of the Convention. So the Tribunal notes that the Commission, during its third meeting on August 2022, unanimously decided to submit to the Tribunal the request for an advisory opinion according to the agreement, and the request was submitted by the Tribunal by the co-chairs of the Commission. So the second prerequisite was fulfilled. And third is relating that the request has to concern legal questions. Caracciolo will analyze the questions, but I will just say that the Tribunal considers these questions having framed in terms of law, because to respond to these questions, the Tribunal is called to interpret the relevant provisions of the Convention and of the COSIS agreements, and to identify also other rules relevant to international law. So the Tribunal concludes that the three prerequisites were fulfilled. So in addition to these three prerequisites, it is necessary for the Tribunal to assess whether the questions posed by the Commission constitute matters which fall within the framework of the COSIS agreement, and the Tribunal was satisfied that in the present case it was so, and it had sufficient connection with the purposes of the COSIS agreements because they were directly related to matters which fall on the framework of the agreements. So for the aforementioned reasons, the Tribunal finds that it has jurisdiction to give the advisory opinion requested by the Commission. The Tribunal also analyzed the issue of its discretionary power to decline to render an advisory opinion in the case, because Article 138 provides that the Tribunal may give an advisory opinion. So the Tribunal has a discretionary power to refuse to give an advisory opinion, even if the conditions of the jurisdiction are satisfied. But the Tribunal further stated that it is well settled that the request of an advisory opinion should not in principle be refused except for compelling reasons. There were some possible reasons argued by one or two states. For example, the lack of consent of states no parties to the COSIS agreement to any aspect of the request that may constitute a ground for the Tribunal to decline to give an advisory opinion. But the Tribunal notes that an advisory opinion is given to the requesting entity, which considers it desirable in order to obtain alignment as to the course of action it should take. And an advisory opinion as such has no binding force, as we know, and the consent of state non-members of the requested entity is not relevant. So also the Tribunal highlighted that the vast majority of the participant states expressed support and did not give rise to any compelling reason for the Tribunal to exercise its discretion to decline to give an advisory opinion. Another reason could be that the Tribunal might decline to exercise its jurisdiction is the possibility that the questions raised by the request may be closely related to questions which are subject to a dispute affecting the rights and obligations of the third states that have not consented the request. And the Tribunal states that it was not aware of any legal dispute between the members of the Commission or any other states relating to the subject matter. So the Tribunal finds that the request was compatible with its judicial functions, as it is called to clarify and provide guidance concerning the specific obligations to state parties to UNCLOS by interpreting and applying the provisions and other rules of international law. So it concluded in regarding the discretion, said that the tribunal deems it appropriate, as it said in the slide, to render the advisory opinion requested by the Commission, and stress that the tribunal is mindful of the fact that climate change is recognized internationally as a common concern of humankind. So the tribunal is also conscious of the deleterious effects that climate change has on the marine environment and the devastating consequences it has and will continue to have on small island states. So bearing this in mind, the tribunal will provide clarifications on the issues raised by the Commission. So it is evident that the advisory competence of the tribunal has not had an easy path without being expressly provided for in the convention. But however, the tribunal, since its beginning, considered it necessary not to curtail its powers in view of its future and great task that is called upon to carry out in the protection of the oceans. And although some still consider it to be perhaps a dubious decision, there are a clear minority, and it's almost a consensus after the Vivian-Shea agreement that this decision of the tribunal was motivated, the decision on the jurisdiction, I mean, by the effort and vocation to expand the legal security and the rule of law into the oceans, because really the advisory opinions, advisory jurisdiction of any tribunal is really a contribution to the rule of law in general. So thank you, and I pass the floor to the really juicy part of the advisory opinions.
Thank you so much, Frida, for this wide overview on the advisory activity of the ITLOS, and I am very happy to have had you here. I forgot to recall that you are a professor at the Buenos Aires and Austral University and recently nominated as judge at the ITLOS. So I now can give the floor with enormous pleasure to Professor Ida Caracciolo, who is a full professor at the University of Campania Luigi Vanvitelli and is a judge at the ITLOS, and also the main contributor to the landmark opinion on climate change. So you have the floor, Ida.
Thank you very much, Jem. I'm delighted to be here and, well, also to present some outstanding parts of this advisory opinion, which involved a hard work by the tribunal because of the scope of the request by causes. And the tribunal worked also in a very short time, and it decided to do that because of the feeling of urgency connected with the serious matter as climate change impact on marine environment can be. So I want, of course, express personal opinions or internal discussions, because these won't be compatible with the function I had in the elaboration and adoption of this advisory opinion. And so I will just present some issues which were considered by the tribunal as extremely important key points in the entire logical flow we followed. And won't describe all the advisory opinion because we will stay here until tomorrow, and it will be very maybe not useful at the end. So I will just focus on some aspects, substantial, as my colleague Judge Armas-Lister anticipated. In particular, I will dwell with the contents of the two questions submitted by causes to the tribunal. Then I will dwell with the definition of marine pollution. And then I picked out some specific obligations that the tribunal defined, described, and interpreted, and in particular, the specific obligation contained in Article 194, Para 1 of the Convention, the specific obligation to cooperate, and the specific obligation under Article 192 and 194, Para 5, which are in a certain way milestones within the entire reasoning developed by the tribunal. And starting with the request, you know that there is a big, there has been a big debate on petitum and causa petendi before international courts and tribunals. This topic of petitum and causa petendi has been less analyzed with reference to advisory opinions, advisory proceedings, but it is an important issue also in advisory proceedings, since the concerned court or tribunal isn't free to answer how it would like or wants, but it needs to take into consideration the framework submitted to it by the requesting party, and it needs also to take into consideration the positions proposed to the tribunal, to such a court or tribunal by the intervening states. Intervention usually in advisory opinion has been considered secondary activities. Not many states indeed participate, usually, statistically speaking, in advisory opinions. Italy is one of them. Italy doesn't think that it is fundamental to intervene in advisory, whatever kind of advisory proceeding, but interventions brought before the bring before the court or the court or a tribunal important comments and interpretation, which will be taken into consideration, and they will also answered to by a court or a tribunal take into consideration the perspective. If a state is proposing an important perspective, it is as well important for a court or a tribunal to answer if this perspective is shared, isn't shared, or other the position taken by the international judge. So starting from the request, which I reproduced in this slide, it was composed by two questions intertwined. We will see in a while, and but the beginning of this request is very important because because causes was asking to the tribunal to identify specific obligations of state parties to the United Nations Convention on the Law of the Sea, including Part 12. And then we will see and in particular, these specific obligations to be depicted by the tribunal were obligations concerning prevention, reduction, and control of pollution of the marine environment, vis-à-vis what? Vis-à-vis the effects that result or may result from climate change. And there is a sort of listing, open-ended listing of effects of climate change, so ocean warming, sea level rise, ocean acidification, which are caused solely by anthropogenic greenhouse gas emissions into the atmosphere. And the second question was focused on the protection and preservation of the marine environment, again, in relation to climate change impacts, and the listing, open-ended listing of such impacts included, again, ocean warming, sea level rise, and ocean acidification. So the first point that the tribunal considered to be analyzed was the meaning of specific obligations, both the term specific and the term obligation. Specific, the term specific can have many meanings. So the tribunal concluded that, well, these kind of specific could be interpreted either with reference to more general obligations, but also with reference to specific kinds of pollution or other specificities. So it's the tribunal followed a rather, I'd say, broad approach to this term. Concerning obligations, the tribunal faced a problem, not causes, but many intervening states included in their presentations, in their submissions, orally and in writing and orally, references to liability and responsibility. So indeed, we have primary obligations and secondary obligations. So the tribunal should necessarily clarify if it would have intended the term obligations as to referring to primary obligations or also to secondary obligations, which would have entailed, of course, dealing with liability and responsibility issues. And the tribunal concluded in the negative, as you know, from the advisory opinion, since it took into consideration, well, the case law by the tribunal itself, in particular the chamber, in the case of the sponsoring state, where the request expressly included the reference to obligations and responsibility. And then the tribunal also looked at the request already submitted before the International Court of Justice, where the UN General Assembly asked the court about obligations and responsibilities. So the conclusion of the tribunal were, if causes wanted to have clarification on liability and responsibility, it would have expressly said that. And then there was a second point, sea level rise, because many states participating, states, but also international organization, non-governmental organizations, because before the tribunal there is a possibility for such bodies to intervene, referred to sea level rise, not in connection with pollution or impacts on marine resources, but autonomously, in the sense of baselines, ambulatory baselines, effects on sea level rise, on delimitation. But the tribunal on this point decided that the reference in the request submitted by causes to sea level rise was strictly connected with environmental effects, not on the delimitation problems, because nothing in the causes request and causes submissions permitted to conclude in this as such. Another point was the reference to the United Nations Convention on the Law of the Sea, including Part 12. This, including Part 12, was intended by the tribunal as all of the specific obligation, the task of the tribunal to find out the specific obligations involves all the convention and in particular Part 12 on the protection of the marine environment. However, here I will mention it afterwards, but just to refer here, because causes referred many times, we have many climate change treaties and non-binding instruments. So, and UNFCCC and Paris Agreement, but the Montreal Protocol, but some annex, an annex to the Marpol Convention, and some annexes within the ICAO system. So the problem of the tribunal was how to answer to causes focusing on the UNCLOS, but taking somehow into consideration these group of climate change instruments. The jurisdiction of the tribunal is a jurisdiction on concerning the convention itself, that's all. So the problem of the tribunal was to sort out these problem. And the solution was given by some articles contained in the convention. First of all, article very well known, 293. 293 is that famous article on applicable law, which law can the tribunal apply. It must apply the convention, but also other rules of international law not incompatible. As far as these climate change treaties aren't incompatible with the convention, they can be applied. But you know, there is a big difference between application and interpretation. To overlap the two concepts is a mistake, it's a serious mistake. So it's important to maintain the tribunal was asked to interpret the convention in order to say which specific obligations apply to states in vis-a-vis climate change effects on the marine environment. So the main task of the tribunal was to interpret the convention, not to looking outside the windows to pick out other rules. And so the tribunal referred to some means of interpretation. So the very famous Article 31, paragraph 3C of the Vienna Convention on the law of treaties. And to that regard, the tribunal considered the ICJ jurisprudence, and in particular that a treaty cannot be interpreted in isolation from the remaining relevant norms of international law, either customary or conventional. And then the tribunal made reference to many rules of reference, which are contained in numerous articles of the UNCLOS, and some of them are also inserted in part 12. So they were useful because through these rules of reference, external rules are implanted in the framework of the convention. They are not anymore external. They become internal rules because there is a renvoi to them expressly made by the convention. And the tribunal really was very involved in such a task of harmonizing the convention with the external rules through Article 293, but in particular through the rules of reference. Think that some states in their submissions focused mainly, if not only, on Paris Agreement and the UNFCCC. So the tribunal was submerged by comments and comments concerning pages and pages concerning how to interpret the Paris Agreement or the UNFCCC, while it never be the task of the tribunal to interpret these treaties or other treaties. This is a task which will be faced by the ICJ because it has a wide jurisdiction, including all international law. And then a third point on the request, the connection between question A and question B. Indeed, it's clear. Question B is the general question. Question A is the detailed one, since pollution of the marine environment is just one of the threats to the marine environment. So logically, question B should have been answered before question A. And many states suggested that to the tribunal in their interventions. However, the tribunal decided, notwithstanding albeit being very well aware of that, to follow exactly the order of questions that causes submitted to it. And then rapidly, the pollution of the marine environment. Well, in a certain way, having answered that GHGs are pollutant to the marine environment, probably the tribunal could have stopped and relax a little bit instead of working for months and months on that. This was really an extremely fundamental issue. We've not difficult to face, but with some tricky points in it. I must tell you that we studied a lot science, because to conclude that pollution by GHG emissions was covered by Article 1, Paragraph 1, subpara 4, could be achieved only through having understood, as a jurist can understand the science, through science. From Article 1.1.4, we know that to have pollution under this article, 3 conditions must be met cumulatively. First, we need to have a substance and an energy, or an energy. This substance or energy must be introduced by humans directly or indirectly into the marine environment. And such introduction must result or be likely to result in deleterious effects. So the first point, and here on this point we elaborated a lot, we thought a lot about science. The tribunal concluded that the greenhouse gas emissions are both a substance, because they are chemical products, but also energy, because they increase the temperature of the atmosphere, and since the seas and oceans entrap this heat, heat corresponds to energy. And so there were both components to that end. Then introduced by humans directly and indirectly. Of course, anthropogenic means by humans, so this was rather easy to settle. The problem was the direct or indirect emission introduction, because the carbon dioxide, which is one of the most important GHGs, is directly, the tribunal concluded, directly introduced in the atmosphere, since carbon dioxide it's absorbed by the by seas and oceans. On the contrary, the heat is produced in the atmosphere, and then from the atmosphere it is entrapped, absorbed by seas and oceans. So for the first, for substance, we have a direct introduction for carbon dioxide, while we have an indirect introduction concerning energy. And let me go now to the specific obligations depicted by the tribunal. One is the one of these obligations was that defined in paragraph 1 of Article 194. 194 is a very articulated norm with many paragraphs, different one from the other. The tribunal analyzed all paragraphs, but I will focus on this one because this is really a specific obligation, a basic specific obligations, in the sense that it is at the basis of many other specific obligations contained in Part 12 of the Convention. And these obligation, Article 194, paragraph 1 was considered by the tribunal a very detailed obligation because it contains the modalities, the necessary measure, and also a reference to best practicable means and capabilities. So a lot of inputs come from this disposition. So it is clearly an obligation, and states are required, the states parties to the convention are required to take all measures consistent with the convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source. I will reflect with you on that first part of paragraph 1. So the tribunal, in interpreting these obligation, hold that the obligation can be an obligation, there is no priority between the taking of these measures individually or the taking jointly. Same level, states are free to choose if to do that jointly or individually, even if the kind of pollution caused or likely to be caused by GHGs requires, of course, a global approach, a cooperative approach. States are required to do what? To take measures that are necessary to prevent, reduce, and control. So the problem here was for the tribunal to define the concept of necessary, the term necessary measure. The tribunal held first that the measures must be determined objectively, because you can easily understand if there are a subjective possibility, well, no standard anymore, no possibility to evaluate the due diligence, nothing. All the rest will follow consequently, and it would be very difficult to find common points to guide states. And the tribunal considered that some elements should be taken into consideration to determine the necessary measure. Science. This is, you know, that international judges are not at ease with science. We have that very famous case, whaling in Antarctica by the ICJ, which was criticized by everybody because the ICJ decided at the end not to deal with science. So in that case, maybe the tribunal would have liked to do the same. I don't know, but science was so overwhelming that we couldn't, even if we maybe would have. So science for the tribunal played a crucial role, plays a crucial role in determining necessary measures, but not alone. Science is one of the elements, and the lack of scientific data is not a problem, because precautionary approach will come in assistance to assist states in determining the necessary measures if science is not precise, sufficiently precise. Second element, relevant international rules and standards. And here we have entering from the window the UNFCCC and in particular the Paris Agreement. So the Paris Agreement, these both treaties and other treaties and instruments are fundamental because they permit to evaluate the if a measure is necessary or not, because they give a standard, a sort of standard to the state parties to the convention. And in particular, these two treaties are fundamental because they establish the global temperature goal, that famous well below 2 Celsius above pre-industrial industrial levels, and pursuing efforts to limit the temperature increase to 1.5 Celsius. And the timeline for emission pathways. This timeline is continuously, as you know, modified, adjourned by COPs during the years. And you know that the global peaking will be different for industrialized states and for less developed and developing states. I must tell you that the submissions by party were very divergent on this point. So the tribunal had to face many different, completely different suggestions on this point. One suggestion was very simply one, the necessary measure are those corresponding to UNFCCC, to Paris Agreement, full stop, end of the story. Other said that these two treaties were lex specialis, and therefore they modified the convention. So no application of the convention, just the lex specialis. The other states said that Paris offers only a minimum standard, and that's all. So no impact of it on the determination of necessary measures. The tribunal, well, utilized these two treaties, but highlighted, and this is, in my opinion, very important, that the convention cannot be complied with complying UNFCCC and Paris Agreement obligations. The convention is autonomous. It has its separate sets of obligations, which cannot be reduced in the obligations contained in the climate change treaties. They must interact. These treaties, climate change treaties, are important to interpret the convention, but they do not substitute the convention, and they are not lex specialis, because you can speak of lex specialis if you have a unique set of treaties. But here we have two systems, the law of the sea system and the climate change system. Parallel, they are not in a organized in a pyramidal structure. And then the second part of Article 194, which makes reference to capabilities and best practicable means. You know that in both UNCCC and Paris Agreement, there is this mentioning to the principle of common responsibility, common but differentiated responsibilities. Many states, not causes, because causes was in a certain way have very clear ideas. Other states put many things inside their positions. Many states said, well, this principle, common but differentiated responsibility, inform also the convention, the 1982 convention. The tribunal didn't agree on that assumption because it retained that this principle is a principle within these two treaties, and you know that they are declined. Well, the UNFCCC declines the common but differentiated responsibility in a completely different way from the Paris Agreement. Paris Agreement was adopted at the end because industrialized states were pushing on this category and were very strong against this category of developing countries, which is nowhere defined and which includes the biggest polluter nowadays, China. So, of course, there was this problem to separate this principle, which is unknown in UNCLOS, and this possibility was given by the second part of Article 194, paragraph 1, which speaks of best practicable means and capabilities. So it considers very clearly less developed and developing state, which can have less best practicable means or minor capabilities. So industrialized states shall take the efforts anyway, shall be leading, but all state parties to the convention must comply with the specific obligations contained in Article 194, paragraph 1, according to their capabilities and means. And to that end, the tribunal, I won't speak about that, interpreted very carefully a section in part 12, which deals with technical assistance, because technical assistance is a way to permit developing a less developed state to better comply with the obligations to protect the marine environment. And then the last point, the nature of the obligation. Here the tribunal had many positions proposed by state. Some states considered the obligation as obligation of result. Why? Because it is written measures necessary to something, to prevent, reduce, and control. So the goal is included, is mentioned in the norm. While usually in due diligence obligation, you don't find the final goal. You find the obligation to do something, but not the final goal. Here we have this kind of mixed system, mixed wordings. Other states said that it was an obligation of due diligence, of conduct, and there was a small category of states which said this is a third kind of obligation, neither of due diligence, neither of conduct, neither of result. The tribunal followed its case law from the two advisory opinions Judge Armas-Filter mentioned earlier on, and so it said that it is a due diligence obligation. It is an obligation of conduct, as the chamber said, hold for the sponsoring. The obligation of conduct, such obligation of conduct is interconnected with that of due diligence. And the due diligence obligation the tribunal hold requires a state to put in place a national system, including legislation, administrative procedures, enforcement mechanisms necessary to regulate the activities in question, and to exercise adequate vigilance to make such a system function efficiently and with a view to achieving the intended objective. So this was a sort of key which permitted the tribunal also to highlight the importance of EIA, or environmental impact assessment, because not only the due diligence is satisfied, or the standard, not only through legislation, but also enforcement mechanisms and also vigilance mechanisms of vigilance of control. And the tribunal said this is an obligation of due diligence. It is a peculiar one, however, because it makes also reference to the intended objective. It's impossible to say a priori if an obligation is of conduct, of result, if the intended goal is indicated expressly. It is this is the task of a case-by-case analysis, and with regard to this article, the conclusion was due diligence. And then the problem of standard, and I'm going to the end. Well, the standard of due diligence is a stringent one. The tribunal utilized this expression, which is easy to be understood by Italians because we have the stringente translation. I cannot tell you the difficulty to translate it in French because the French language doesn't know anything comparable. So it's the translation at the end wasn't was found, but less clear than the English stringent. So it's a high standard because the risk is high, because there is a lot of scientific knowledge on that point. The IPCC, Intergovernmental Panel, many times, many reports highlighted the risk. There are relevant international rules and standards describing what must be done. And there is also, this is something new with respect to the previous case law, urgency. So all these factors determine a very high standard. The standard is one for all states. The means can vary according to their capabilities and practice and their economic development. The tribunal repeated more or less this reasoning for other obligations. It highlighted a lot the obligation to cooperate in 1997. It repeated that it is a duty to cooperation. And then it repeated more or less the same reasoning about due diligence for Article 192, which is the specific obligation vis-à-vis impacts to the marine environment different from pollution. And the same conclusions were reached for Article 194, paragraph 5. This is again a due diligence obligation. State are required to take all measures to you see the wording is similar, to protect and preserve rare or fragile ecosystems and habitat of depleted, threatened, or endangered species or other forms of marine life. Here, the tribunal made a lot of references to the CBD Convention, so the Convention on Biological Diversity, to the Convention on Straddling Stocks, and so on, in order to define the standard of due diligence, and also to include the concept of adaptation, which for the tribunal was included in preservation. So preservation may also require adaptation. So you see, it's a very full of contents, advisory opinions, and well, the tribunal was aware of the risk, and it hopes that it could help states in order to fight this very serious problem of greenhouse gas emissions. We are here in September with a July, end of July weather. So this is the most evident issue. Thank you very much.
Thank you so much, Ida, Professor Caracciolo. And now it was really really useful for us to hear the insights and of all this complex opinion, because was not easy at all. Also the interplay with other agreements and with the norms outside the convention, it was really challenging. So now I give the floor to our discussants, starting with Professor Fiammetta Borgia, who is the very recently nominated professor of international law at the University of Rome, Tito Vergata, and then to Professor Andrea Giuri, who is also almost full professor at the University of Macerata, and they are going to discuss and to introduce some key questions on the issue that we heard from our judges, and then we will have a discussion. Thank you.
Okay. let me say something before. I'm very grateful for this invitation as a discussant in this seminar, and it's a true honor to join such an interesting conversation alongside respected scholars and judges, especially women, who have made significant contribution in the field of international law, and with particular reference in the law of the sea. So thank you, Gemma, Professor Armas, Judge Armas, and Judge Caracciolo. And I would like also thank you to President Assidimer and my colleague, Professor Cataldi, and my colleague Andrea, for this invitation. So I prepared some questions, but it's true that your presentation was so interesting and so clear, and that I have to change my mind and make something else. So my first question will be about jurisdiction. And there was a large debate about the advisory function of ITLOS, because some scholars considered this function may be ultra vires function, since there was not an express provision in the UNCLOS or in the ICLOS statute. Today, you make reference to the Article 16, 21, and also in the Article 138 of Rules of Procedure. And what I found very interesting is this link between Article 16 and 21 that is not present, I think, expressly in the advisory opinion. And do you think today there is, you both, do you think today there is the need to fortify this function or not? And if whether you think that there is no need, it is because it's an inherent power of ICLOS, or what is your perspective in this topic as a scholar and not only as a judge? That was very clear. Also in the jurisdiction, it's true, probably the legal basis today is sound. But what I feel that is the process is not so clear, it's not so strict or stringent. Do you think that there is a need to make a framework or make something else or not, and how? And this is for the jurisdiction. And I have another point that is about the.
I lost the first part of the second question.
Yeah, in the process, because you mentioned three requisites. And three requirements: international agreement, whatever body authorized, and legal question. So you think that the process in clarify this concept has to be improved or not, or it's okay that? And the other point is about the discretion of ICLOS. ICLOS Tribunal can refuse or reformulate the question posed. How this function can remain effective while safeguarding this discretion in the ICLOS? Is this a strong point or not, this power, and how to manage this power? And then the last one is very, very general question. Climate change is today a big issue, and is an issue that is today in multiple courts, national and supranational, international, that I prefer. So these, and also in the advisory opinion, in the advisory function, do you think that is this kind of situation with multiple questions in multiple space court is promoting cross-fertilization of international law, or this can carry the risk of fragmentation of international law? That is my question today, very general. Thank you.
Okay, thank you very much. Yes. Okay, so the first, remind me something you want to complete or I get something wrong. Explanation of the tribunal, the first one, when the tribunal analyze if it has a jurisdiction and where it comes from. And I think that it was important in that moment because the tribunal wanted to strengthen the role of Article 21 of the statute. So Article 16 was the power or the right of the tribunal to draw its own rules of procedure, and from there they went to Article 21, and that's why Article 21 was according to the convention, and also it's interesting the way they stressed the role of the annexes of the convention as part of the convention. So they have the same status and level than the other. So I think that it was very good. And in this one, I think that it was not mentioned, Article 16, but it comes, all the tribunal starts from what it has said before. So it was Article 21, and from Article 21, and for me, it's also very important because some of the critics before, the people who have criticized the advisory jurisdiction of the tribunal from the rules of procedure from Article 138, put a special highlight, especially that it was something that the tribunal has given itself. And the explanation of the tribunal going from Article 16, 21, and the international agreement. So it is not the competence, the advisory jurisdiction of the tribunal doesn't come from the Articles 138. It comes from 21 and the international agreement together. So I think that it's a strong fundamentation, but I'm not sure that everyone's understood it. So perhaps the need is for us scholars to continue elaborating on it. But I think that also in this advisory opinion on climate change, when the tribunal highlighted that first, its reasoning on the advisory jurisdiction was accepted by most of the states, because in the meeting of state parties, states have pronounced themselves on favor of this. Then at the oral and written proceedings, there were most of states in favor of it, and of the BB&J agreement. So it's like the tribunal is saying, well, we said this in the case 21, but all these subsequent activities of the states, practice of the states, are showing that we were right. That's my way of understanding it. And in relation with the three requirements, it's true, it's not perhaps striking, but I think that it is clear now that there are three requirements, and everyone is looking at them when and this advisory opinion on climate change is clear. No, that yes. We said this, so we are going to look into this. But I join this with the discretion of it laws. I think that the tribunal is also making its own jurisprudence on both issues. No. Of course, it can reformulate in a way the question, or it can refuse. But the tribunals also stated that it's only in, I don't remember the phrase, but only in case of necessity, that it will not give the advisory opinion. No, that it's so I think that it's a power that the tribunal has, probably to use when it could become a political request and not a juridical one, when it can be it can prejudice the impartiality that the tribunal has to have as a judicial body. If you want to ask something more or to add. And relating the multiple courts, national and international, yes, really, it's amazing, because if we look into the European Union, the national tribunals, and what is happening also at the International Court of Justice, if you want to read the papers, and then in December to be present online, but the oral hearings, we have a lot of work to do, and we have a lot of time to dedicate to this. But I think that I prefer to think that it's a cross-fertilization than a risk of fragmentation, even though, of course, there is a risk of fragmentation. But I think that it's good that the tribunal, which has to deal with the convention and not in general, was the first one that issued the advisory jurisdiction. So, and there are a lot of potential in this advisory opinion, which really, I can praise it because I know it's not bad, but really it was amazing. Like the detail in which the tribunal deal with each of the issues, well founded really. So I hope that this will help all the other tribunals to elaborate on it. Not perhaps the same, but not also against. No, so I'm on the positive side of cross-fertilization and not fragmentation, but it's my point of view. Thank you.
Yes, I will add few words. Well, we teach to our students that states are sovereign, and the agreement confers. Agreements they conclude are at the basis of everything. So an agreement conferring the jurisdiction to the tribunal is something absolutely normal. There is anything new on that. The new is the interpretation, if we can say that, interpretation of Article 21, in the sense that all matters has been interpreted in a let's say, peculiar way. But the fact that two states conclude a compromise or an arbitration treaty and they submit a case, it's in the normal order of normal way of let's say, relations between states. So I think that this is well established now. I fully agree with Frida. It's completely well established. Concerning the prerequisites, probably you didn't notice, but that's normal. It's a very big, but I had to check because I remember something. The prerequisites are those in Article 138. Full stop. No other. But the tribunal, in paragraph 105, in addition to the aforementioned prerequisites, Article 21 lays down that the jurisdiction of the tribunal extends to all matters specifically provided for, and so on. So this is not a prerequisite in the sense of Article 138, but it is a prerequisite. We could say 4 prerequisites, but since these requisites are contained in different articles of different relevance. One is an agreement, the other one is the rules of procedure. The tribunal decided to maintain the distinction between the first category of prerequisite, and then it added in this paragraph these other prerequisite. And fragmentation or not, well, or cross-fertilization, but which are not exactly the same things, completely different. But cross-fertilization when we are drafting, negotiating a new treaty, so states look at the previous one to take information, to copy, partially copy it, or cross-fertilization among judges. But we have never had in any sector opposing conclusions. We speak of course cross-fertilization in this sector, but the ICJ concluded in Nicaragua, Colombia in a completely different way than the tribunal in the case Bangladesh and Myanmar. It's a problem of cross-fertilization, the interpretation of the outer limit of the continental shelf, different one by the ICJ and the Tribunal in 10 years. It depends, the judges is called to act case by case. It's not, he's not writing a book, he's not writing a manual, he's deciding a dispute before it. And so it is not, it's the problem of cross-fertilization, believe me, and fragmentation are, let's say, outside the mind in the moment when you are deciding. Then there are the judges who are professors, which elaborate on that on the other side of their heads. But it's not a problem, because you have a case and you have a jurisdiction and you have an ammissibility issue and you have articles mentioned by the party. We cannot, if a state mentioned 2 articles and not the one fundamental in approach of cross-fertilization, the judge cannot apply that 3rd article because it's not mentioned by the party. Because petitum and causa petendi are limits within which the Tribunal and the ICJ and the European Court of Human Rights is called to decide. So there are some technicalities which let's say don't allow a judge, an international judge, to think too much theoretically. This is a proper way of thinking in the field of scholarship, but in judging, no, I don't think so.
Thank you so much. I would give the floor to Professor Caligiuri for his question.
Thank you, Gemma. Thank you for inviting me as a discussant in this interesting seminar. Thank you for your presentations. And I limit my role as a discussant to address you some questions on key concept of this recent advisory opinion. The first question concerns the concept of applicable law in the case. The ITLOS advisory opinion gives a central role to the concept of systematic integration of international law, and the Tribunal explains the relationship between the obligations under Part 12 of the Convention and external rules, focusing on Article 237 of the Convention and on the Article 31, paragraph 3, letter C of the Vienna Convention, the law of treaties. Well, I wonder why ITLOS did not complete his reasoning on the interpretation of the Convention rules by also referring to the role of the general conflict clause in Article 311. Does this mean that Article 237 has the effect of excluding the provisions of Part 12 from the application of Article 311? Yes. Does it mean that Article 311 can only regulate the relationship between other international treaties which do not create a specific obligation with respect to the protection and preservation of the marine environment, and the other parts of UNCLOS except Part 12? This is the first question. A second question concerns the concept of best available science, and ITLOS in this case, but generally recently many other international tribunals or courts place science at the center of their considerations. And in this advisory opinion, the Tribunal affirms that measures states adopt to meet their legal obligation in respect of climate change should be in line with the best available science, which is crucial in meeting the standards of due diligence states are held to. Aetlos did not define the term best available science. And how does a tribunal define its scientific legality? How does a tribunal define the legal construction of science in a case? In general, what criteria do a tribunal or court use to determine what should be considered good science or junk science before deciding what is best available science? A third question concerns the application of the principle of common but differentiated responsibilities. In the context of marine environment, what the principle of common but differentiated responsibility means that states, particularly developing states, could argue that a distinction should be made between states on the basis of historical considerations and responsibility for their greenhouse gas emissions. And in the end, very quickly, in the height loss affirms the need to assist developing states, states with lesser capabilities to implement their, to meet their environmental responsibilities. But it is worth noting that ITROS does not define the concept of developing state eligible for technical assistance. Could you give some ideas on how to identify such states? Should only scientific data on the negative impact of climate change on countries be taken into account, or should other economic or social criteria also be considered? That's all. Thank you.
Let me say something preliminary. The tribunal heard from 90% of states which participated to the proceedings that its task was interpretation, application, no lawmaking. So in many cases, and in all the, save the first one, all the questions you put to us now, there is a component of lawmaking that the tribunal couldn't never ever have faced because it's a judge and not the General Assembly or I don't know, COPs and so on. So the first point, systematic interpretation, which is linked with the problem of cross-fertilization, because this is a very, because the problem is to interpret a rule, not in isolation, but and in a way as much as possible harmonized with other treaty dealing with the similar or same fields. Because on the contrary, states will face opposing duties. So one will nullify the other and vice versa. So we discussed a lot on that. This is a big issue. So the tribunal referred to those articles it applied, not those it didn't apply in the case at stake. That's the only thing I can tell you. Of course, there were theoretical discussion on the relationship between these articles and so on. I must say that the Italy submission was focused on that. Was one of the few focusing mainly, well, the Italian exclusively, but at length on that. But we were dealing with part 12 mainly. We referred to rules concerning the EZ, fishing in the EZ and on the high seas in the part answering question B, but mainly part 12 was our focus, and so we utilized the three means I told you, even if I must tell you that we discussed on all the possible relevant rules in the convention. Best available science. We were lucky because in that sector, climate change, the science is certain. So we had so many reports from the IPCC along the years, because IPCC was established in the 80s. So even before the Rio conference, that which is really it works in a very analytical way, because a lot of scientists involved, and then the screening by other scientists, and then the screening by states in that summary for policymakers, that really there are voices outside the IPCC which criticize the IPCC data and conclusions, but very few, and not founded at all, considered by the vast majority of scientists as completely unfounded, with data completely scientifically wrong. So we were lucky because we didn't need to elaborate on best science. We found best science in the IPCC. Of course, in other sectors, the problem will be a serious one, because the problem is a jurist try to interpreting science. And I don't know if you noticed, but we put scientific aspects at the beginning as a background, not after jurisdiction and ammissibility, because we wanted to make very clear that science is not a problem for a jurist. A jurist cannot touch the science, and so we put it as an in a part where usually judges and international judges describe facts, events, and so on, in order to highlight that we were outside from the scientific interpretation, which is not the task of a court. But this is a very sensitive issue, and you know that the problem of external experts has always worried the courts, international courts and tribunals. And the problem of common but differentiated responsibilities, you know, we were judges, and we will be in the future judges of the ITLOS, so of the UNCLOS. So we didn't want to interpret a concept, common but differentiated responsibilities and capabilities, which is completely external to the convention. It's a concept uncertain, because I told you the two UNFCCC and Paris Agreement don't correspond on it, contains different different define it in different ways. They find out specific obligations for various categories of state, UNFCCC, and the Tokyo Protocol as well. And while Paris is more diluted because of some countries polluting a lot, so we applied what UNCLOS contains on that. So this reference to best applicable best practices, capabilities, assistance to developing states. In one case, we could also say that assistance can be financial because the rule allowed us to interpret it in such a way. But we maintain, I don't remember if we said that or in 194 or on technical assistance, we highlighted that there is something in common. The idea that states economically and scientifically and technologically are not equal. So these equality among them must be taken into consideration. So there is this common this core point, common element, but then the solutions are completely different. So this is the reason why, and we couldn't define developing states because the category is not defined anywhere. So we would have done lawmaking.
This is fine, but in different ways.
Yes, so you know, and also assist states with less capabilities. We wanted to highlight that there are some category of states which are more vulnerable than others. Small island states, this is clear. Lowland states, Bangladesh. If you see the Bangladesh presentation, is pictures of the river and the flood and the salty water entering the river, destroying everything, and the reservoir of fresh waters, and so on. So we wanted to highlight that there is not an exact overlapping between developing under the perspective of the convention, because of course desertification wasn't our problem because we cannot interpret desertification. But concerning the effects of GHGs on seas and oceans, there were some states more vulnerable, which must be to which the convention refers in providing that they can comply with the obligation, take into consideration their capabilities, and with the assistance of the other states.
Thank you so much, Professor Caracciolo. And I would open now, because we have still a few minutes for a discussion from the public, and then we will have the conclusion of Professor Cataldi. And I have immediately one very practical question, because you mentioned the external experts. So I wonder if you have had the necessity, or you had any external experts convened?
I can't answer.
Okay, so but,
sorry,
but because actually this should be a very hard task for lawyers. I mean, to look through reports of IPCC and to understand the functioning. So you may need an assistance in doing this. So
well, really, I cannot,
okay.
because everything
Okay.
is written here,
Okay.
and all the rest doesn't count.
Okay. Thank you so much. So I open the floor to the public. Is there anyone that wants to pose a question, submit a question to our speakers? No one? Okay. Yes. You please. You can join this in order. Maybe. Thank you so much. In a few minutes with
Okay, so considering that this advisory opinion can have a moral authority and fostering, developing the international law, do you think that it established a link, a strong link, I think, between the international law of the sea, which is status-centric, state-centric, and the climate change, in order to the obligation to diligence? This advice opinion can play a strong role at the national level in the reduction of marine pollution.
Maybe if we have other questions, we can. Any other? No, no. Okay, that's all.
Well, you know, causes the problem of small islands states. As I read from the reports and following, let's say, the life of the international community, they are powerful because they are capable to ally among themselves to create very active international organizations. And you know that in the law of the sea, the distinction between big powers and small states blurred completely, because it's not the land territory which counts, but the sea spaces. So we have small island states with enormous sea areas. So they are very active in negotiations and so on. This is not the case in the climate change system. So it happened that these states tried to obtain a result of enforcing the reaction against climate change where in the field where they are stronger, much stronger. And so I think that they will pursue these objectives. And so this will help through also the ITLOS advisory opinion, help in strengthening, at least with reference to the marine environment, states' obligations. I don't know, I might envisage, for example, a domestic case, a case submitted before domestic courts and tribunal, where parties will utilize the advisory opinion to demonstrate to the judge having to deal with compensation and so on, some conclusions contained in the advisory opinions. These states were forced to do through international courts and tribunals what they cannot achieve at the negotiating level, also because multilateralism nowadays is practically close, near to death. So they utilize what is active nowadays, jurisdictions, international judges.
I just said that in the sense this of the influence of a small island developing state is true. When I was working in other issues with them, they call themselves big ocean states. They are not small island states, but big ocean states, because they are they have this archipelagic baseline, so they are big ocean states, and really they are very active, as Judge said, and they're having a lot of influence in all international areas, different, because not only by themselves, but also by their regional organizations. They have AOCs and this Pacific Forum agency. So, and they really know they have a role as a regional organizations, whether it's a meeting or something relating to regional organizations. But also, I think that even if the advisory opinion is, all of us know, is not binding, but it's authoritative, and it really, I think that this advisory opinion has a lot of of has a lot of meat on it, as we said in Spanish. I don't know if it, a meat of it in the sense that it will surely it will be quoted by national tribunals. It will be, I don't know if quoted, but international, but at least take into account. I mean, if you put in internet now, advise your opinion, climate change, it takes a lot of different countries who put on their newspapers and in different, and this of course permitted to the national tribunals. I guess, perhaps I'm wrong, but I'm sure that it is the case. So I think that it will definitely will have, because it is a landmark. I mean, you can be, you can agree with it or not, but it is not the same before this advisory opinion than after this one. For me, it's really something that is a landmark. Yeah.
Thank you so much. And now we, and just to say that those big ocean states have actually have had many results in the latest multilateral success, and the only multilateral success that was a BB&J agreement adopted in 2023, and there the small island ocean states actually received a lot of specific provisions in their own interest. So actually they began big ocean with the BB&J as well. So now I thank you so much for all these efforts for today, and I have the pleasure to give the floor to Professor Giuseppe Cataldi, who is a full professor of international law at the University L'Orientale of Naples, and he is also president of the Association of the International Association for the Law of the Sea, and I am very happy you are here, so I give you the floor.
Thank you, Gemma. I am very, very happy of this initiative, of having been involved in this initiative. First of all, because it gives me the possibility to come back here to the ISG, National Research Council, Institute of International Studies. I used to be the director of the Neapolitan seat of this institute, and I have spent much time here in this building for years with many of you and other people that we are still in touch, and really I hope that all these wonderful initiatives, not only concerning the law of the sea, which this institute creates, will last long, because I am firmly convinced of the usefulness and may I say of the impossibility of not having an institute like this one in Italy. So I hope that it will last long. This is me. Okay. And may I also add that I'm very happy also that International Association of the Law of the Sea is part of this initiative today, which I represent as its president. We are growing. We are growing also thanks to some people here, as Andrea Giuri and others. We are trying to develop also, may I say, our personal basis and national basis, because we have recently also have some new members, not only physical members, but also associations which takes care of base and so on. So I think it is very interesting what is going on with this association. Thirdly, I am happy, and it is not rhetoric, because I have seen that as a male sex representative, I am a minority here. And it is very interesting and important because, believe me, and I'm talking to the young people, this was impossible to achieve up to 25 years ago. So it is really a very, very important achievement. So coming now to the conclusion. Well, it is not easy for me to draw the conclusion of this very interesting workshop. First of all, because so many things have already been said and already been asked by also Andrea Fiammetta. But there is also another reason, because I written some notes, and my intention was to reread these notes this morning in the train, but I fell asleep as usual. As you know. So okay, I try to do my job. First of all, what is an advisory opinion? And let me quote a definition. An advisory opinion given by the International Court of Tribunal is an authoritative, but in principle non-binding statement or interpretation of international law. To use advisory opinions as a means to clarify a legal issue is something which is not so recent. So why I quote this definition? Because we have, first of all, to say something about the issue of the legal basis, which has been debated. But in my opinion, it's very easy to draw a conclusion on this, even if there have been scholars quoted, very important scholars, as Tanaka, Orlando, or others, who has written that the reasoning of the Atlas reasoning on this issue is not convincing. Remember that in the European Convention of Human Rights, it is written in Article 46 that judgments are binding for states. Notwithstanding this, in 2003, the European Court of Human Rights said that interim orders of the European Court of Human Rights are binding. And this is very hard, you know. This is maybe ultra vires, because we are talking of something binding. That's why I quoted the definition of advisory opinion. Something binding, which was not binding up to 6 months before, but in 2003, the European Court of Human Rights changed its jurisprudence, case law, in the famous Mamatkulov case against Turkey, saying that interim orders are binding. In the same period, some months before, some weeks before, the International Court of Justice had told the same in the Lagrand case concerning the case of the United States versus Germany, for the first time affirming clearly the binding nature of its interim reports. For what concerns International Court of Justice, there were no precedents. It was the first time that this was in a certain way affirmed, and there was no explicit exclusion in the statute. Different is the case for the European Court of Human Rights, where it is written clearly, judgments are binding, are legal by force. Stop. So this maybe can be ultra vires, even if practice in the following years is in a certain way, may I say, convinced all the skeptical commentators of accepting this solution. Here what we have something completely different, an advisory opinion, which is not binding. So in my opinion, we have not to be so formal as someone has been in judging the famous word matters as too narrow, or too wide to justify this interpretation given first of all in the rules of the tribunal, and then in the first advisory opinion given by the tribunal. So this for this part concerning the legal basis. Coming to the issue, the content of the advisory opinion, the tribunal had a very, very difficult task. Why? Because, as we have seen, the request concerning, first of all, mainly part 12 of UNCLOS. And so UNCLOS had to take care of a set of rules which are an empty box. You can confirm me this, because, you know, in part 12, UNCLOS is not so specific, not so goes not so deep as in other part of the convention. So it gives a certain room to interpretation and to renvoi to international conventions concerning environmental issues. This is a difficulty for the tribunal, but it is also, may I say, an assist, a possibility for the tribunal. Because, and this is my second point, we have to put in mind something which, of course, is very easy, very natural, but let me underline that climate change, ocean acidification are not mentioned in UNCLOS. All these issues are at stake now. They began to be discussed 20, 30 maybe years ago, but not in the period of the third United Nations Conference on the Law of the Sea. So the tribunal had to make an effort, I think an important and very useful effort, to bridge in a certain way UNCLOS to climate change issues. And this really will be something which, as Frida was told before, will be a landmark, will be the basis of future development on this issue. And I really am I'm looking forward to read what will be the future development for International Court of Justice and International American, Court of on this issue. Another thing I want to add, because all other things I have noted already been commented, so for also question of time, I don't want to to stay much on it. Is a reference to an important point which we find in the decision of April 2024 of the European Court of Human Rights on these issues. Why I want to mention it? Because it gives us the importance of the ITLOS decision, the ITLOS opinion on these issues. Because what the European Court said in particular, and many things on this, in this case is once again a female case, because the
future,
yes,
the future.
Kliman Signorinen. It's wonderful, this definition. The Kliman Signorinen, yes. I would like to meet all these Kliman Signorinen.
They were a bit aged. If you want.
Also myself now, I'm beginning to be a little. Anyway, but they are Signorinas.
Yeah.
The European Court of Human Rights rejected an argument, very important argument that the Swiss government put on the table, the famous drop in the ocean argument. So the Swiss government said, okay, but we have to understand what should be the climate situation with the Swiss action or Swiss inaction. Will be a difference, because if there is a difference, okay, I have to pay. But if there is no difference, what is the problem? Of course, no, this is not the correct way of reasoning. The correct way of reasoning is, of course, the finding that reasonable measures which the domestic authorities failed to take would have had a real prospect of changing the course of events or mitigating the damage caused. And so you see, I don't know if they took care of this argument because the European Court have written this a month before or not. But what we have heard by the two distinguished judges about the due diligence, about the stringent, this difficult but very important word, and about the what Judge Caracciolo said before, the fact that also if we there is no difference on developed states and developing states on this issue. Means are different, the way are different, but they are different is different. But the may I say the responsibility is the same. So I think that once again we have had a proof of the importance of this tribunal, because in the past, but also nowadays, sometimes we often read, but what was the sense, the use of putting this competence in UNCLOS? There was the ICJ, there were other possibilities. No, International Tribunal of the Law of the Sea has once again given us the proof of the importance of having this institution, and all the interventions by NGOs, by international organizations, by states that were mentioned before, but that you can, as you know, follow on the internet whenever you want, compose a system of opinions, of competences, which we need, because this issue of the climate change is something which concerns each of us. No one can say, okay, it's not my task, it's not my case, someone else has to deal with this problem. Unfortunately, no. We are all involved. So many thanks to International Tribunal of the Law of the Sea, because it retained its competence and because it gave us an important point of reference to start from for our future studies, for people who are engaged in the academy, but what is more important, for decision makers. Thank you very much.
So thank you so much to all the colleagues and students present here, but also to all the colleagues that I see in online, and I say bye-bye to everyone, and thank you for having followed us today. Thank you. Bye-bye.